All right. Hello and welcome to week 9, commercial remedies. And for some reason, which I don't understand, my camera is working this week, unlike last week. Good. All right. So we've got 5 questions for tonight's tutorial for week 9. And in the internal groups, I would break all the students up into 5 groups, and they could spend some time working together to answer the questions, and then we could answer them as a large group. But we don't have that luxury. So instead, I will plow on through and give you the answers. So go onto Blackboard, read the instructions. You'll see there some indications about which podcasts you should have worked through before attempting the questions. And we'll go through and talk about them. So, question 9.1. If you need to, definitely feel free to pause the podcast and try yourself to answer the questions as we go. Computer being awkward. There we go. All right. So 9.1, part 1, regarding the house contract. Undue influence may be presumed where there is a special or confidential relationship. A special or confidential relationship has been acknowledged to exist in the case of, for example, a religious advisor and devotee, and you can cite Allcard and Skinner as the case authority. Allcard, Allcard, and Skinner. It's from round bracket 1887, close round bracket. 36, Chancery Division at 145. There seems to be the relationship between Reverend Nathaniel and Gerald in the question. The onus switches to the party in whom the confidence was reposed to show that the undue influence was not used and that the transaction was independent and well understood. An act of free will, if you like, and you can look at Johnson and Buttress. And for those of you who did equity with me, you'll remember the Johnson and Buttress case when we looked at unconscionable conduct and undue influence. Failing this, the contract is voidable. The small consideration that Reverend Nathaniel has agreed to pay would make it difficult for him to discharge the onus. It's likely that Gerald will be able to rescind the house contract. Unconscionability might be an alternative to consider. An unconscionability may be established where the one party is at a disadvantage, a special disadvantage, and the stronger party knows of this disadvantage and seeks to exploit it. You can cite the well-used case of Commonwealth Bank and Amadio. Gerald's lack of education might qualify as a special disadvantage if Nathaniel knew about it. There may be an argument that he exploited it, and this would also entitle Gerald to rescind the contract. Regarding the car contract, Gerald might rely on a plea of non est factum, which you'll remember from previous studies also. He belongs to a relevant class, that is, the class of persons who are unable to read because of blindness or illiteracy, and who must rely on the advice of others regarding what they're assigning. Secondly, he belongs to a class of persons who, through no fault of their own, are unable to understand the purport of the document. B, he signed the document believing it to be radically different from what it is in fact, actually. And C, at least against innocent persons, he was not careless. And you can cite Petelin, Petelin, and Cullen, Cullen, round bracket 1975, close round bracket 132, CLR at page 355. A successful non est factum plea will result in the contract being void. Title can't pass under a void contract, so Gerald would be able to recover the car from the car dealer. Here, there's no difficulty showing element B as a pledge of sobriety is radically different from a transfer. In relation to element A, further evidence regarding Gerald's lack of education is required. Does he lack education to the extent of being illiterate? Alternatively, it's the case that his lack of education means that through no fault of his own, he can't understand the purport of the document. In any event, it would seem that the plea is being raised against an innocent person, the car dealer, and it would be very difficult for Gerald to show that he was not careless in signing. He did not seek independent legal advice. Indeed, he signed without even asking a question. So, it's a difficult result that might follow if the car dealer had been colluding with Clancy. In that case, Gerald would be raising the plea against a party who was not innocent. In such a case, only the first two elements must be shown, and the element of carelessness need not be established. Petellin and Cullen, again, is your authority. The success of the plea would depend on evidence obtained in relation to the first element. If the non est factum plea was unsuccessful, there are prima facie a number of grounds on which the contract might be rescinded. For the same reason that we've already discussed, there may be an exploitation of a weakness that amounted to unconscionability, as described in Amadio's case. There may have been an actionable fraudulent misrepresentation by Clancy about the nature of the document Gerald was signing. A statement of an existing fact made prior to signing with the intent of inducing the contract, which was known to be false. Depending on the evidence, Gerald might be able to show an exercise of undue influence. In each case, even if he can make out a claim, the principal remedy is a right to rescind the contract. However, there have been an intervention. I beg your pardon. There has been an intervention of an innocent third party for value. That's the car dealer, which means any right to rescind has been lost. Again, if the car dealer is acting in collusion with Clancy, the right will not have been lost. In any event, the claim for fraudulent misrepresentation gives rise to damages in tort for deceit against Clancy, and if she can be found and is worth suing. That's always the question, isn't it, in some of these commercial matters. Okay, so take a moment, read 9.2, and we'll consider 9.2. So both parties here have made the same mistake, namely that the record accurately reflects their agreement. Tilly, sorry, my dog's just, Tilly. She's just defending our property. A contract can be rectified for common mistake where there was a prior complete agreement and the parties then erroneously record the agreement in a written document, and the bona fide rights of a third party are not prejudiced. That's a really good rule. So it's Maralinga, Maralinga, and Major Enterprises. I'll just repeat it. Both parties make the same mistake, namely that the record accurately reflects their agreement. A contract can be rectified for common mistake where there was a prior complete agreement and the parties then erroneously record the agreement in a written document, and the bona fide rights of the third party are not prejudiced. Take a moment, read 9.3, and the first part, advise Jacko whether he may be able to avoid the contract with bashers at common law. Well, To avoid the contract at common law, Jacko would need to rely on either economic duress or unconscionability. Economic duress may now be taken as meaning actual or threatened unlawful conduct directed at the legitimate commercial and financial interests of the plaintiff, according to Australia and New Zealand Banking Group and Karam, K-A-R-A-M. The bashers have not used unlawful conduct towards Jacko's commercial interests, notwithstanding that the bashers' director has knowledge of Jacko's difficult financial position due to his gambling debts. The evidence does not suggest that the bashers have done anything worse than maybe offering a harsh business deal to Jacko when he was already in a difficult situation. Given Jacko's form, his slump of form, it may be quite appropriate for Jacko to be offered a shorter and less valuable new contract than his teammates. Any common law remedy for conduct not amounting to economic duress would need to be based on another ground such as unconscionability. Again, it's the ANZ and Karam case. This requires the claimant to show that they are in a position of special disadvantage and that the other party knows or ought to have known that they were in that special disadvantage, and then the other party takes unfair advantage of the claimant's position. Again, Amadios case is a good authority there. That idea of special disadvantage refers to circumstances that could include poverty of any kind, sickness, age, infirmity of body, infirmity of mind, drunkenness, illiteracy, lack of education, lack of assistance or explanation where assistance or explanation is necessary. What a great definition for special disadvantage. And you can cite Blomley and Ryan, B-L-O-M-L-E-Y and Ryan, for that very broad and helpful definition of special disadvantage. So apart from the possibility of self-induced poverty due to gambling debts, there's no evidence that Jacko is suffering any of these circumstances. Presently, he's earning $500,000 a year. It would be difficult to conceive. Silly, come on. Sorry. It would be difficult to conceive that the court would look kindly on any poverty argument. Jacko's only special disadvantage would seem to arise from commercial vulnerabilities. Excuse me again. Sorry, everybody. Come on. Come on. It's okay. Sorry again. I'll go back. So presently he's earning $500,000 a year, and it would be difficult to conceive of a court that would look kindly on any sort of poverty argument there. Obviously, that makes sense. Jacko's only special disadvantage would seem to arise from a commercial vulnerability, such as he feels he has no alternative than to accept the new contract from the bashers on much less favourable terms. However, commercial vulnerability, no matter how extreme on its own, won't amount to special disadvantage. And you can cite the Australian Competition and Consumer Commission and Barbatis Holdings, B-E-R-B-A-T-I-S, Barbatis Holdings. So, to obtain a remedy under statute, Jacko would seek to rely on either sections 20 or 21 of the Australian consumer laws. Students that participate in my internal shoots have been talking about the provisions, I suppose, just recently. So we haven't covered section 21 in any great detail as yet, but we will do that as the semester rolls on. But if we look at section 20 sub 1, we can see that it prohibits a person in trade or commerce engaging in unconscionable conduct within the meaning of the unwritten law. So the exact meaning of the section hasn't been uniformly agreed upon, but section 20 sub 1 is the prohibition that in commerce or trade, no one should be engaging in unconscionable conduct. So it's only intended to provide the remedies, I suppose, under statute for unconscionable conduct as identified in Amadio's case. You can see why I think it's such a helpful case. And it's not going to help Jacko. The section does not apply to conduct prohibited by Section 21. However, the Australian Consumer Law, Section 21, is wider. In particular, Section 21, Sub 1, Sub B, prohibits a person in trade or commerce in connection with the acquisition of goods or services from a person, other than a listed public company, from engaging in conduct that is, in all circumstances, unconscionable. So in this instance, the bashers are acting in trade or commerce in contracting to acquire Jacko's services. Services can be defined broadly to include a contract for or in relation to performance of work. When determining if there's been unconscionable conduct by the acquirer in connection with the acquisition of goods or services from a supplier, the court is entitled to consider, without limitation, the list of matters under Section 22, Sub 2 of the Australian Consumer Law. The relevant matters might include the relative strengths of the bargaining positions, and that's in Sub A. And here we've got the bashers having much greater bargaining power in the circumstances. Under subsection D, pressure exerted on or unfair tactics used on Jacko by the bashers would be covered. So while there's pressure to sign the contract being exerted on Jacko by the bashers, and the director of the bashers was aware of Jacko's gambling debts, the facts don't directly support a claim of unfair tactics. We've got sub-paragraph F, whether the bashers' conduct is consistent with their conduct in other similar transactions, and that might be relevant to Jacko if he's the only player on the bashers' books being offered a new contract that's less attractive than his existing contract. Further evidence would be required here of whether there are any other players also underperforming but not being offered less attractive contracts. That would be very useful to know. Paragraph J, the director of the bashers didn't seem willing to negotiate the terms and conditions of the new contract, which were offered on a take-it-or-leave-it basis. And paragraph L, the extent to which the bashers acted in good faith, given the bashers' knowledge of Jacko's gambling debts. The question is whether this knowledge has been used to seek to gain a contractual advantage in a manner inconsistent with their dealings with other underperforming cricketers. So while Section 21 affords Jacko the greater prospects of success than available at common law, further evidence would be required to be satisfied that Jacko will be able to establish a claim under the Australian Consumer Law. If successful, Jacko would be entitled to remedy under the Act, particularly Sections 237 and 243, which would allow the court to declare the contract void. And these remedies will be dealt with over the coming weeks. Then we have Part B of that question. Just teeing it up because it's just run a bit forward. Part B of that question, assuming rightly or wrongly that Jacko cannot avoid the contract, can the bashers recover the total sum of $15,000 by way of liquidated damages for the 3 separate instances that Jacko arrived to training late? So to recover the sum of $15,000 by way of liquidated damages, the bashers would need to seek to rely on the liquidated damages clause in clause 10. If the sum fixed by the operation of clause 10 is a genuine pre-estimate of the loss flowing from the breach, it will be accepted by the court and awarded as liquidated damages. It's no obstacle to the sum stipulated being a genuine pre-estimate of damage that the consequence of the breach is such as to make the precise pre-estimation almost an impossibility. However, where the sum fixed bears little or any relationship to the loss incurred, the clause may be struck down as being a penalty. Factors which the court will have regard to in determining if Clause 10 is a penalty will include the bargaining power of the parties, the intention of the parties, whether the stipulated sum is clearly in excess of the greatest possible loss that might be expected to flow from the breach, and the presumption that the stipulated sum is a penalty if it is payable on the occurrence of one or more of several events, some of which result in serious and others only in trifling loss. So on these facts, pardon me, it would seem that Jacko had little bargaining power with the contract being offered. It was on a take it or leave it basis. And while more facts, again, might be needed to really determine the intention of the parties, it's clear that the loss may be suffered by the bashers, dependent on the length of the delay. In circumstances where the agreed damages clause makes the sum of $5,000 payable regardless of the length of the individual delay, whether it be 3 minutes or 3 hours, the clause is likely to be presumed to be a penalty and struck down. This will leave the bashers to prove their loss in the normal way. So, it's not a consumer contract, and the ACL provisions in relation to unfair contract terms won't apply, but we can also make a note in our work that there are changes being planned to the legislation. So that's 9.3. It's a very full tute, this one. Next two questions are large as well. So 9.4, pause this and have a read. Prep your answer if you can. Is the contract void for mistake as to identity? 3 elements need to be satisfied. Firstly, at the time of the agreement, the identity of the other party was material. Secondly, that he intended to contract with a different entity. Thirdly, that this intention was known or ought to have been known by the other party. And you can cite Boulton Jones, Boulton, and Jones, Cundy and Lindsay, Cundy, and Lindsay, Lindsay, Kings Norton and Ederidge, Kings Norton, Norton, and Ederidge, Edridge, Edridge. Despite the prior telephone negotiations, this contract was made face-to-face when Rebecca met with Jean-Paul. In contracts made face-to-face, there's a presumption that the intention was to contract with the person who was present in the face-to-face dealing. You can cite Philip and Brooks, Louis and Avery. This means that the contract is presumed to be between Rebecca and Jean-Pierre. It is a question of fact whether the presumption can be rebutted. Here, 3, these must all be sub-questions. 3, here the result is not clear. Rebecca would need to argue that identity was material and that she intended to contract with someone else. These elements are not overly problematic. However, it's not clear whether Jean-Paul knows Rebecca intends to contract with Pierre, although there might be some argument that he ought to know, or given their conversation, Rebecca's statement that he was a well-known celebrity chef. 4, if Rebecca can overcome the difficulty in establishing the third element, the contract would be void for mistake as to identity. This would mean that Rebecca would not be liable for the balance of $180,000. Whether she can recover the deposit would depend on whether there was a total failure of consideration, and there would be here. 5, if not void for mistake, was there an actionable common law misrepresentation? Well, 2 possible misrepresentations relate to, firstly, identity, and secondly, experience. To form an actionable misrepresentation, it's necessary for Rebecca to establish that Jean-Pierre made, firstly, a false statement, secondly, of a past or existing fact, thirdly, addressed by one to another, fourthly, before or at a time the contract was made, and fifthly, it was intended to induce, and in fact, it did induce the contract. So we'll take identity first. And these are the two possible misrepresentations. Identity. Well, the elements are not made out here, as there are no express statements by Jean-Pierre that he was Pierre. Mere silence is not normally a misrepresentation or a misstatement, except in certain circumstances, and here it has not distorted any other statement regarding identity, and it is neither a fiduciary relationship nor a contract of utmost good faith. Experience. Well, elements 1 to 4 aren't a problem. Jean-Pierre has made the representation that he has undertaken large-scale projects before. Despite never having done a large job, he made the statement to Rebecca during their conversation, which occurred prior to the formation of the contract. In relation to 5, you might want to outline the rules of inducement in relation to whether it induced the contract. Well, we know the statement need not be the sole or decisive factor. It's sufficient if it was a real inducement. And the case is Edgington, Edgington, Egdington, and Fitzmaurice, Fitzmaurice. Rebecca is not required to take steps to verify the statement, as she's entitled to take Jean-Pierre's word. And you can cite Redgrave, Redgrave, and Heard. As outlined in Gould and Vagelis, Gould, Gould, and Vagelis, Vaggelas. The rules of inducement state: 1. If the representee does not rely on the representation, they have no cause or no case. That makes sense. If the representation is made to induce the representee to enter into a contract, and that person in fact enters into the contract, it can be inferred that the representation induced the contract. Third, an inference can be rebutted by, for example, by showing that prior to entering into the contract, the representee either knew the true facts or, regardless of their knowledge, made it clear the representation was not in fact being relied upon. Here, there's no evidence that Rebecca knew of the true circumstances. In fact, it seems to be the opposite. And she has not made it clear that she was not relying on the representation. Excuse me, again, quite the opposite. So where a false statement is knowingly made by the representor, or where he or she makes it not honestly believing it to be true or recklessly careless as to whether it's true or false, it will be fraudulent. So this is round 8. Derry and Peak, Derry and Peak, Peek. In the circumstances, it appears likely that the statement about his experience was made by him, knowing it to be false or recklessly indifferent to its truth. And this is certainly not a case of negligent misrepresentation, as there isn't a special relationship between Rebecca and Jean-Pierre. Question 9, prima facie, fraudulent misrepresentation entitles Rebecca to rescind the contract, so she would not have to pay the $180,000 and could recover the $20,000 and recover any damages in tort for deceit. 10, it is necessary to establish that there are no applicable limits on Rebecca's right to rescission, which will be lost if, and these are important, the contract is affirmed, or through lapse of time, or where an innocent third party acquires an interest in the subject matter for value, or where restitutio in integrum is no longer possible. Restitutio in integrum. Note that the limit concerning executed contracts is not relevant here, as this is not an innocent misrepresentation. So in relation to restitutio, you know what I mean. It may be that Jean-Pierre has incurred expenses in readying himself for performance. However, in the case of fraud, the court will be more lenient and allow a rescission, despite the fact that precise restitutio is not possible. And you can cite Alati or Alati, Alati, and Kruger, Kruger. I know that one. Alati, and Kruger. Okay. Now, you weren't asked about Section 18 under the ACL. We can think about a bit of a summary of the position, perhaps, just to fill out your work if it's been on your mind. There may be a claim under Section 18 of the ACL for misleading and deceptive conduct. Pierre is considered a natural person, it's not an incorporated entity. However, the ACL has been implemented into Queensland law through Section 16 of the Fair Trading Act, 1989, Queensland, which applies to individuals and others who do not fall within the scope of the Commonwealth ACL. So that they have to be acting in trade or commerce, and this certainly is a situation which you could class it as trade and commerce, and you might cite O'Brien and Smolongon. I'm really sorry. Smolonogov. Smolonogov, and I apologize. You would also need to identify that Pierre engaged in conduct. Conduct under Section 2, Sub 2 of the ACL would include acts, statements, submissions, and it would encapsulate silence. You can cite Demagogue and Ramensky. Section 18 of the ACL prohibits misleading and deceptive conduct and to mislead an ordinary member of the community into error. Parkdale, and Puxu, Puxu. Silence will be seen as misleading when there's reasonable expectation that a thing existed or should be disclosed. That's Ramensky's case again. This is difficult to determine precisely in a commercial setting, and the final decision will depend upon the context of the silence. Unlike common law, the position under the ACL creates a duty to disclose Jean-Pierre's identity if there had been a reasonable expectation that it would have been disclosed. In this context, Rebecca mentioned his status as a celebrity chef. He did not disclose otherwise. Therefore, Jean-Pierre's silence amounts to conduct, and it's likely to be misleading, given that Rebecca was seeking Pierre, the celebrity chef. Furthermore, the statement about his experience is clearly false and would also amount to misleading conduct. The remedy would be under... No. It's okay, Tilly. Sorry. Tilly. The remedy will be... Okay, sorry about that again. Very vigilant puppy I have. There we go. Okay, I can't do that. That's fine. So I was saying that remedy would be a rescission under Section 237. No obligation to pay the balance and return of the deposit, and there's no issue with the limits to rescission here. Damages under 263 of the ACL for the wasted invitations would be available. It's not necessary to show a causal link between the conduct and any loss. That would not be a problem here. So yeah, if you did consider Section 18 of the ACL, that will help outline the answer for you. And we're on to the last question. So take a pause, read it through, and I'll give you the answer if my dog will let me. Come over here. No, she's okay. She's sitting over there. Question 9.5. Okay, A. Helen may terminate the contract for repudiation, and you can refer to Foran and White, Foran-Wight. In addition to the termination, Helen may also claim damages from Don for the loss suffered as a result of the repudiation. Pardon. The measure of damages will usually be the difference between the contract price and the market value of the property. The purchaser will be able to seek the return of the deposit in addition to any damages on the basis of restitution. Alternatively, Helen may seek specific performance of the contract. As it is a contract for the sale of land, Helen may be successful. B. The question that this problem raises is whether Helen will be entitled to the equitable remedy of specific performance or injunctive relief. Generally, specific performance will not be available for contracts for personal service. This is clearly a contract for personal service. And you'll remember all that stuff we did in equity about that too, hopefully, particularly if you're in my group. However, pardon me. However, it's possible that Helen may be entitled to injunctive relief to prevent a breach by Dame Carey of the express negative promise in the contract. That is, the promise is not to sing for anybody else during this time. The question requires the discussion of the cases of Lumley and Wagner and Warner. So Wagner and Warner are obviously the defendants. Lumley is the plaintiff. So it's Lumley and Wagner and Warner Brothers Pictures. No, that isn't how it is at all. I think it's Lumley and Wagner is the one case. Lumley and Wagner is the one case. And the other case you can look at is Warner Brothers and Nelson. Yeah. And in these cases, the injunction was granted to restrain a breach by the singer and actress, respectively, from entering into contracts with other parties. There was controversy around the decisions, in particular Warner Brothers and Nelson. It effectively required Bette Davis to perform for Warner Brothers for 6 years more. And in the other case, they required only 3 months. So it's those sort of, and you'll remember them from equity as well, where you're being prevented from working for another company in a similar vein. Okay, I believe they are your questions, and I did that in a way that I'm hoping you've read and prepared, and you can pause it and do your work. Maybe listen to the podcast, go back, and then try to answer them yourself in detail, and then do it again, try it again, just so as we're getting to late in the semester, you have more opportunity to practice for exams, etc. All right, all the best, and thanks very much for your time.